May I please lordships?
Yes.
My lord, I beg to mention item number 13.
1-3.
Yes, my lord. My lord, if this can be taken up on Monday,
At the request of the learned counsel for the appellant.
appellant.
List this matter again on 18th of May. 18 May 2026.
Bless my lord.
Lordship, I beg to mention item number 12, my lord.
12.
Yes, my lord. Lordship, on a consensus prayer, my lord. If this matter can come up on Tuesday, my lord, 19th.
On 19th.
Yes, my lord.
At the request of the learned counsel appearing for the appellant, list this matter again on 19/5/2026.
Obliged, my lord.
My pleasure, lordship. Lordship, I beg to mention hearing item 11, lordship.
11.
Lordship. If this matter can come up after 2 weeks, lordship.
2 weeks.
I have some personal difficulties.
At the request of the learned counsel appearing for the appellant. This matter again after 2 weeks. But
Much
it's a 2018 matter.
Lordship, lordship.
Why? He's in jail now.
Lordship, lordship.
He's in jail.
He's in jail.
1826. 8 years gone.
Yes.
2 more years to go. Then
Lordship, 2 weeks, lordship. I'll make sure we'll take it. Much obliged.
Lordship, can I mention item number 9? I
Nine?
mean 5.
Huh?
5.
item number 9 and 10 are connected.
So Lordship, 5. Lordship,
5.
yes, 5.
Okay.
Lordship, here I have instruction to appear on behalf of respondent 4.
What? But we have to see what has happened to the service report of the others.
Lordship, the thing is, he's transferred out, so the new incumbent has to be implemented.
That is one part. If the others have been served or not, that we will see.
Okay.
But for you, we'll keep it in mind when we take up the matter.
Yes, Lordship, Lordship, I beg to mention item number 8.
8.
Yes.
Yes.
Lordship, on the last occasion, I took 1 week time to file vakalat number. However, the concerned officer was out of station. So, Lordship, another 1 week time may be granted to file vakalat number on behalf of respondent 1 and 2.
1 and
for,
2.
Yes. And for 3, I've already filed yesterday.
Administration Council who has submitted that she would require another week's time to file the wakalatnama
Yes.
on behalf of the respondent number 1 and 2.
Yes.
And she has already filed the wakalatnama on behalf of the respondent number 3.
Yes.
Allowing the accommodation, list this matter again on 20 May. Oh no, 20 is a division bench. 21st of May?
Lordship.
21st of May?
Yes.
Lordship, I'm appearing on behalf of Mr. Mual Jamir. Since
Ms. So-and-so appears of the petitioners. She wants a week's time to file the wakalat.
Okay, Lordship.
Lordship,
Yes, Lordship.
Yes, ma'am.
I beg to mention item number 2.
2.
Yes.
Let 1 happen, then we'll go to 2. Huh? Let 1 be called, then we'll take up.
Lordship,
Yes.
Lordship, I beg to mention hearing item number 14. Lordship, yes. Lordship, I'm appearing on behalf of my senior Ma'am Apila Sangdam. She's indisposed, so if the matter could be listed on 11 June for hearing.
The request of the Learned Council appearing for the respondent number 4, who is stated to be indisposed. List this matter again on the 11th of June,
Yes, Lordship.
2026. Mr. So-and-so appeals for the petitioner who does not object to the same.
Obliged, Lordship.
Obliged, Lordship.
For item number 1. May I please, my lord? Your Lordship, I'm representing respondent number 2 and 5. Your Lordship, we have filed an affidavit bringing on record that we have taken steps to regularize the service of the petitioner as per the procedure prescribed under the office memorandum. However, on 2 occasions, our proposal was rejected by the MRC, asking us to resubmit again.
Right?
Your Lordship, will find the first proposal rejection on my affidavit in opposition, and the second rejection, Your Lordship, I have submitted it before this honorable court that by a letter dated 5th of December 2025. Again, it was rejected again, Your Lordship,
By whom?
by the MRC, Manpower Rationalization Committee.
But here it says that order at page 11, repetition order says that cleared post for creation of Khalashi 5 numbers when the petition is included in 5. Serial number 5.
Your Lordship, yes.
Then what happens?
No, Your Lordship, in my affidavit, Your Lordship may kindly come to my affidavit in opposition. I have filed here. Your Lordship will find that 19 post was sent to the MRC. And the MRC rejected it on 13th of July 2023. Your Lordship will find that at page 10. Here,
10. Where?
page 10 of my affidavit. Page 10.
Oh, that is prior to, huh?
Yes, page 10. So this is the first rejection. Your Lordship, thereafter we submitted again. And by 5th of December 2025, MRC has again asked us to resubmit by following.
No, the 13th of July 2023 is prior to the order of this court. Is it?
13th, Lordship.
Your order of the court of this court was of which date? 26/9/2023.
Yes.
Then, so therefore, your page 10 cannot be prior to the order.
No.
Yes. What do you say? Page 9 of the contempt petition is the order complained of.
Yes.
It was passed on 26/9/2023.
Yes. Yes.
Then your page 10 is 13 July 2023.
Yes. You know, Your Lordship, this is because the
Then
petitioner.
page 11 is 21st of August 2023.
Yes, the petitioner has already completed 30 years of service by then.
True. Since
Yes.
it was not happening,
Yes.
because of those 2 letters were also not being taken care of,
Yes.
this court said that do it
Yes.
within 6 months.
Yes.
What did you do?
No, we took steps, Your Lordship. Even
Which
before
step?
that, we
No,
took steps.
after that is what we want to know.
Yes, Your Lordship. We have again compiled everything as per the recommendations of the MRC. And we have placed it again before the MRC, and the MRC has rejected it again by a letter dated 5th of December 2025. I have placed it again, Your Lordship.
Where is the 5th of December?
Your Lordship, on the last occasion, I have already placed this letter 5th of December 2025. And I have informed this Honorable Court that the respondent department is preparing again. As per the advice given by the MRC, we are preparing again to be placed before the MRC, Your Lordship. Or else, Your Lordship, I have the copy of this.
Please show us what are these.
Yes.
What is this 4/3/2022 and 13/7/2023? 13/7. Where is the rejection for this at page 10? Where is the rejection for this person?
Page 10 of my affidavit, my lord, or
Out of your affidavit, you
Yeah.
said 13 July it was rejected, is it not?
13 July 2023.
Where is
Yes.
the rejection for this person?
Your
Or
Lordship,
for that batch? Where is it?
Your Lordship will find at page 7 the approval of the Finance Department. And Your Lordship will find the name of the petitioner at serial number 5.
We saw that.
Yes.
That is what the court had taken into consideration. When passing the order,
Yes,
the court had already considered that letter.
yes,
Then you are saying that you have given that regularization part, you
Yes.
forwarded a proposal,
Yes.
It was not conceded to. You are referring to 13th of July 2023 at page 10.
Correct. Correct.
Which is the thing?
Your
Where
Lordship,
is the rejection?
your Lordship here, see, Your Lordship, for the, Your Lordship recommendation, if I may allow to read the recommendation. The committee examined the PNR and finance clearance and recommended creations of one post of leader to regularize the work charge employees as per the office numbers and such. The post shall stand abolished. Your Lordship, the next one. For the remaining posts, the department is asked to re-examine whether due procedure was followed in respect of all the work charge employees and submit the proposal with strong justification. So the remaining posts for the 19 posts, Your Lordship.
Then why are you placing it through the 19 posts? This man has got a writ court order in his favor.
Lordship.
The other 18 also got writ court orders.
Your Lordship.
Probably not.
Yes.
Probably not.
Yes.
Bring it to the notice of the MRC that this is a writ petition. No further justification is necessary. Do it.
Your Lordship, there is
Have you
there is a procedure prescribed as to how the service of the work charge employees are to be regularized.
Is it required to be taken up with the 13 persons, with the other 18 persons? No.
Your Lordship,
What does the High Court say? What does the order say of the order of the High Court?
Your Lordships, if I may be.
Page 11 of
Yes.
the
Yes.
contempt petition.
Yes.
Considering the fact that the finance department has examined the proposal and concurred with the regularization of the petitioner,
Yes.
along with other work charge employees who have completed 30 years of continuous service.
Yes.
So cleared post for creation of Khalasi number of post shown at 5,
Yes.
wherein the name of the petitioner has been included as serial number 5.
Yes.
Court finds it fit to dispose the writ petition with the direction that the state respondent shall take further necessary steps
Correct.
and issue the appointment order. Now,
Correct.
this appointment order was later on converted into a regularization order by
Correct.
later order
Correct.
of the petitioner within 6 months from the date of receiving a certified copy of this order.
Correct. Your Lordship may kindly come to para 4 of the same order, my Lord. Page 9. If I may be allowed to read this, my Lord. The petitioner was then promoted to the post of work charge Khalasi in a scale of pay. By an order
According to the
that
OM.
Yeah.
According to the OM.
yes.
Now, where is the OM?
Your Lordship, the OM is not annexed in the contempt petition by the petitioner, but the OM says, Your Lordship, first the department has to compile it, send for PNR verifications and clearance, then to finance department, then to
done.
yes, then
It's
to
already done.
yes, then to MRC, then to cabinet.
So who is not doing it? The MRC is not doing it.
Yes, because Your Lordship, there was some technical defects there. So the MRC have requested the department to resend it.
How many times?
Your Lordship, on 2 occasions, and we have verified everything as per the recommendations made by the MRC, and we have already placed it before the MRC again.
When?
Your Lordship, allow me to place it, Your Lordship,
When have you placed it before the MRC now?
on 12th of the May, Your Lordship, if I may be allowed.
12th of May.
Yes, if I may be allowed to place it on record.
Let us.
Your Lordship, the relevant portion, if I may be allowed to read. Just the paragraph that starts with the post stands abolition on the 4th paragraph, my Lord. The post shall stand abolished as and when vacated by the incumbent. The next, Your Lordship. The matter for creation was earlier submitted to MRC, however, via data number dated 5th of 12, 2025. The department was directed to comply to the PNR OM dated 22/9/2024. In compliance with the direction, the department has regularized 2 driver posts based on the above PNR OM. Meanwhile, the department has also submitted 28 grade 3 and grade 4 technical posts to PNR for verification of pins for the regularization of the OMS. The proposal for creation of 76 various posts to regularize those work charge employees who have completed 30 years of service is therefore submitted to the Manpower Resignation Committee for
You
consideration.
are saying that this contains the name of the petition.
Yes.
Okay. Your name?
Visoninho.
You have anything to say?
My lawyer.
Heard Ms. Swenson and counsel paying for the petitioner. Also heard Mr. Swenson and counsel paying for the respondent number
2 and 5.
2 and 5.
For one.
Madam Swenson appears for the respondent number 1. The counsel paying for the respondent number 2 and 4 has placed before this
2
court.
and 5.
2 and 5 has placed before this court a communication dated 12th of May 2026 from the Joint Secretary to the Government of Nagaland, addressed to the Chief Secretary and Chairman, Manpower Rationalization Committee, Nagaland, whereby the proposal for creation of 76 various category of posts to regularize those work charge employees who have completed 30 years of service was submitted to the Manpower Rationalization Committee for consideration and approval. It is a submission of the Learned Council that the name of the petitioner is also included within the 76 number of persons proposed to be regularized once the posts are created. Full stop. The court observes that the order of which non-compliance is complained of is of the year 2023. The respondent number 2 and or the respondent number 5, who is the senior officer between the two?
No, Your Lordship, the respondent number 2 was the former secretary. He was transferred and therefore the new incumbent, respondent number 5, has been implemented, ma'am.
The respondent number 5 shall cause an affidavit to be filed
Lordship.
before this court detailing the steps taken and also indicating that the case of the petitioner has been forwarded to the
MRC.
MRC for creation of posts to regularize the petitioner. Full stop. List again after 4 weeks.
4 weeks.
Along with the affidavit required to be filed by the respondent number 5.
Deeply obliged, madam.
Tell us on that yes, his name is included.
Your Lordship, if it is done, then it will be placed before the cabinet for necessary approval. So
Once that is done,
yes,
this court can presume an attempt to comply. Is it not? Once we presume that there is an attempt to comply,
yes,
we can say, okay, to be placed before the cabinet 2 more weeks, 3 more months. But if we say that you are not putting up the documents, non-compliance,
yes. Correct.
please, we can invite him here for a cup of red tea. We don't want to do that. Okay.
I'll my friend.
Let's sit after lunch then. Huh?
Deeply obliged, madam.
Thank you.
What is the next? Five already mentioned that. Five you want yeah. Look, I got there to pick up the number.
Yes.
For admission, item number 2.
Yes, what were you saying?
Lordship, I'm appearing on behalf of the lead counsel for respondent 1 and 2.
Hmm.
Lordship, the matter has been forwarded to the PNAR for approval, and as such, the PNAR has given their approval. Now, accordingly, we are reconstructing the service book. Therefore,
You
if
are
you want
reconstructing the service.
to, yes, Your Lordship.
How much time will you need?
3 weeks, Your Lordship.
Yes.
I'm for the petitioner, Lordship.
What do you say? She's asking for 3 weeks.
Lordship, I have no objection.
No objection. Okay. Your name is?
Alitosul. Alitosul.
And your name?
Mr. Jamir,
And you are appealing for?
respondents 1 and 2.
Ah,
Your Lordship, I'm appearing for respondent number 3 on behalf of my senior Joshua Shiki.
okay. Attendance pale. Heard so and so, so and so. The Learned Council appearing for the respondent number 1 and 2 has submitted that the compliance with the order which is complained of as not being complied with is under active process and may require 3 more weeks to be fully complied with. Full stop. Accordingly, place this matter again on 12th of June 2026.
Much obliged, Lordship.
For admission, item number 3.
May I please your lordship? I
Yes.
beg your consent for appearing through VC lordships and for the respondents.
Hmm.
Lordship, the present matter which has been placed before your lordship has challenged the section 35(3) of the CGST Act. Lordship, that same matter has been pending before the Apex Court, Lordship. And the next date before the Apex Court is on 25/2026. So I pray for a date after that, Lordship.
When is it next listed?
25/2026, Lordship.
Yes, you are paying for the petitioner.
Lordship, I'm for the petitioner.
What do you say?
Lordship, so in this matter, we are on interim right now, Your Lordship. And as the matter is subject to the decision of the Apex Court, Lordship, the interim may continue and it may be taken up on the next date that Your Lordship may fix.
Okay. You are Mr.
Keys in Lordship.
And the petitioner, your name?
P. Jalan, Your Lordship, on behalf of A. Goyal.
Heard Mr. Swinson and counsel paying for the respective parties. It is submitted at the bar that the issue involved in this petition is also under consideration of the Apex Court. And a joint prayer has been made to have the matter listed after 2 weeks, awaiting the adjudication by the Apex Court. Full stop. Accordingly, list this matter again on. We'll keep it on the second week of June.
Lordship.
In the second week of June. Stop. The interim orders passed earlier shall continue.
Much obliged, Lordship.
Much
For
obliged, Your Lordship.
others, item number 4.
Please, Your Lordship.
Yes.
Lordship, here I'm appearing for respondent number 1, 2, 3, 4, and 5. Lordship, during the pendency of this case, respondent number 1, there's one Dr. Joyce Din, she expired. So by the order dated 9/3/2026 of this honorable court, we were asked to furnish details of the legal heir to represent her. Lordship. However, we could not find anyone. She is unmarried, and then so we could not find anyone to represent her. So, Lordship, if necessary orders can be passed,
Then
we can proceed.
Acha. In the original litigation, who had signed the affidavit?
It's respondent number 1 in the IA.
No, this is not the IA, this is the civil division. Is it not? I'm asking who signed the original
Yes, that
affidavit?
is this. They have filed IA 2 IAs, and both the IAs, this respondent number 1 has signed, and we are challenging the order of the IAs arising out of the IA.
Yes, my lord. It was the respondent number 1 who
Respondent
signed
number one, but the other persons,
Yes, my lord.
the other respondents here,
Yes, my lord.
how many are there?
There are other four of them, my lord.
Now that the person who had sworn the affidavit doesn't change, the other respondents have to file their own affidavits, saying that despite the death of the respondent number 1, we seek to pursue, and whatever was signed by her, we ratify it, and we want the litigation to
I
continue,
can do
and
the needful, my lord. I can do that.
we want to continue, and we have no objection if the
Lordship, I'll do the
revision abates against the respondent number 1, and you also move an application saying that the respondent number 1, it is abated. So whatever will remain now will remain with the others. You want to continue.
So, Lordship, in the form of an affidavit?
You have to file an affidavit.
Lordship.
Only then we can continue.
Lordship,
Otherwise, we do not have the stand of the other persons. Is it not?
Lordship.
They have not shown the truth of the statements made,
Lordship.
or that they are willing to continue even after the death of the. But then here you have filed the revision, huh?
Yes, yes.
You have also to file an affidavit that you have come to know about the death, and then only we can say it is abated. Verbal submissions, what can we do?
Lordship, in respect of respondent number 6, we have taken thus this step, and affidavit has been filed to that.
That affidavit is filed. Your name?
Prohibitions.
Mr. Counsel opinion for the petitioner has submitted that the steps on the respondent number 6 has been taken, and an affidavit to that effect has also been filed today.
Yes,
That's
sir.
it. Study the said affidavit is not found on record. Registry to list this matter again in the 3rd week of June 2026. The parties would be at liberty to bring the fact of the demise of the respondent number 1 by way of affidavit before the court.
There is an interim, Lordship.
The interim order passed earlier shall continue.
For others, item number 5. May I please, my lord? Lordship, I have instruction to appear on behalf of respondent number 4, Mundemo Paton. Whereas, however, he has been transferred out from the state of Nagaland. So,
But you have to file an affidavit saying that he had done what he had to do, and that he is now no longer here, and therefore he cannot pursue the matter. Once a notice has been issued on contempt.
Lordship, for respondent number 2, I'm appearing for the first time, so I may be given some time to obtain instructions.
But
I'm also appearing for the first time, actually.
it's all right. You get your wakalatnama. You get a short affidavit filed that whatever was required to be done during my time, I have done. And now I'm no longer in the office, I cannot pursue the matter. It is only then he can look around for the new incumbent and get him in. You also have a copy served on the new incumbent, without which you will not be able to make him a party.
Yes, my lord. I'll second.
How much time was given in the writ petition? What was the time frame given in the writ petition? Any time frame given?
4 months, 4 months.
4 months. Now, after you serve a copy on the new incumbent, you have to wait for another 4 months. It
My
has to
lord,
be
enough
properly
time has been
noticed, is it
given to
not?
them.
Huh?
Enough time has been given to them. Enough time has been given to them. I've already filed my.
That is all right. That man who was supposed to do it, he
Yes,
is not
ma'am.
in office. He has gone from here.
Yes, my lord, but the intention is, my lord, now.
But so his affidavit he will have. But if you want the order to be complied, you must bring on the new incumbent.
Yes, my lord.
Otherwise, he will not work.
Yes, my lord.
Have you served him a copy of the
No, I
order?
was not aware. I was not aware that he has
Mr.
been
Counsel,
transferred
the
out.
counsel appearing for the respondent. Okay, say it like this. Heard the learned counsel for the petitioner. You are Mr. Angami, senior.
Yeah, Angami.
The learned senior government advocate has submitted that he has instructions to appear for the respondent number 4. He submits that as per his instructions, the respondent number 4 is no longer holding the office of the Principal Secretary, Public Health and Engineering Department. This court notices that the appropriate wakalatnama has not been filed on behalf of the respondent number 4. You are Miss?
Yes, maybe.
Appears for the respondent number 2. And submission will be allowed some time to have her instructions and file appropriate wakalatnama. We'll stop according the time. Read for. List this matter again on
After 4 weeks, Lordship.
18th of June.
Fine, my lord.
Huh?
Fine.
So 18th of June 2026, by which time the counsel for the respondent number 4 shall file appropriate wakalatnama and affidavit. And there is respondent number 2 and 4 shall file affidavit and wakalatnama. What about the others?
Others, Your Lordship, there are another,
4 and 5 are from the same office, my lord.
But the persons are different contempt.
yes.
Each one will have his own burden.
Yes, my lord.
Huh?
3 also is yet to
Appear.
yes.
Mr. Solicitor and Counsel paying for the respondent number 1 has sought for some time to have his instructions and to file the affidavit. Who is the Deputy Secretary? Respondent number?
4, Principal Secretary.
This is another problem. They're all sending these matters to that what MRC or something, na?
Yes,
And
my lord.
MRC is never a party, so MRC keeps returning the file.
Yes, my lord.
How will you get it complied with? Same letter. He appears for the respondent number 3. None.
None.
Yes.
You had taken steps.
Yes, my lord.
When?
14/11/2025. AD post in 18/11/2025, regular post.
The last office note dated 16/4/2026 reflects that the service report in respect of the unrepresented respondents is still awaited. List again on when? 18/6. And with an updated service report. You also take your steps.
My lord, and can you allow me, Dusty?
Huh?
Dusty on 3 and 5.
Contempt, it doesn't come dusty on first service. I can allow you to accept second. You want it?
If possible, Dusty, my lord.
But he says the respondent number 2 is not there.
Two is
4 is
there.
not there. He has left. First have a copy on respondent number 4, the one who's holding the
Yes, I'll do it.
Include him, then we'll give the dusty.
Fine, my lord. I'll do it. Nice, my lord.
For others, item number 6.
Yes, Mr. Devnath.
May I please, my lord? My lord, as per office note dated 28/5/2026, though it will be 28/4, I have taken the steps upon respondent number 6 and 7 as directed by this honorable court by order dated 24/2025/26, my lord. And services upon the respondents are still awaited.
This on 11th of June. Awaiting service report on the respondent number 5 and 6. No, 6 and 7.
6 and 7, my lord.
6 and 7.
For others, item number 7.
You are appearing for whom? I did not notice.
I was appearing for the claimant respondent 1 to 5.
Mr. Swense appears for the respondent number 1 to 5.
Method.
You have filed your objections.
I filed it today, ma'am.
You filed it.
Yes, ma'am. Let's make.
This is the item number
7.
7. Yes.
Your Lordship, I've taken step upon the.
Where is your weapon?
Yes.
Where is your weapon?
Lordship,
Weapon.
I have not been handed over.
You don't have a weapon.
I have not been handed over the case file. The senior counsel is out of station.
How can you appear before a court without a filing?
My apologies.
At least carry a tab or a mobile. Look into it. Yes.
So I have taken steps upon the respondent on 24/4/2026, and the service report is awaited. So I pray that sometime may be granted.
Office note dated 27/4/2026 reflects that this return of service was awaited. List again on same 11th.
Yes,
11th of June 2026 with updated service report.
much obliged, sir.
For others, item numbers 9 and 10.
Yes.
Lordship, service upon respondent number 4 and 5 is still awaited.
List again on 11th of June. Awaiting service report on respondent number
4 and
4 and 5. You are appearing for respondent?
Lordship, actually, I've entered appeared for respondent number 1 to 3, madam. However, I find my vakalat but it was rejected. So
Why? Why is the wakalat number rejected?
The only respondent number 1 signature was here. So one.
Mr. So-and-so submits that he has instructions to appear for the respondent number 1, 2, and 3.
Yes.
And shall be filing his wakalat number shortly.
Obliged.
Lordship.
For hearing, item number 15.
Yes, madam.
May it please, my lordship.
Hmm.
Lordship, this is the third round of litigation. The first writ petition was filed before this honorable court, that is writ petition 16/2019 was filed before this honorable court challenging the termination of the petitioner by order dated 27/2/2019. Lordship will kindly come to termination order is set. Petitioner's appointment is at page.
Just a moment, madam. Yes, tell us.
Petitioner's appointment is at page 17, next year A. He was appointed on 17th January 2014. Shall I read out, Lordship?
Okay. Yes, 17.
Then page 18, annexure B is his termination order. This was issued from West Bengal. What happened is that the petitioner slapped a colleague who was at the residence of the respondent number 4, that is commandant. They were colleagues, a cook. He slapped a cook because he did not take permission and went out at night without the knowledge of Assamese or Nagamis. And he was newly appointed and he used to go out at night without permission. So he was a guard in the residence of respondent number 4, that is Commandant Lordship. So that previously also he was warned, but he went out without permission. So at night, when the cook came back at night, the petitioner slapped the cook. They were together. So because of that only, the next day at night that happened. Then the next day from West Bengal, where the respondent number 5 was stationed at that time for election duty. Respondent number 5, that is commandant. This order was issued without even issuing notice, in violation of principle natural justice. Temporary service of number so and so Hotoshe of F admin company is hereby terminated with immediate effect on disciplinary ground. Accordingly, he is struck off from the strength of this unit with immediate effect. So this was the termination of the petitioner. So the petitioner challenged his termination, annexure C, page 19.
Yes.
The first writ petition. Writ petition number 16K 2019. Now, Lordship will kindly come to the last page 20, paragraph 6, from paragraph 6. Bare perusal of the termination order dated 9/6/2016 prima facie shows that no notice has been issued to the petitioner, nor an inquiry has been initiated against the petitioner prior to his termination of his service. However, as the petitioner had not availed of the alternative remedy available before approaching this court is not disposing of the writ petition on merit. Liberty is, however, given to the petitioner to file a representation to the respondent number 3 and 4 with regard to the petitioner's prayer for setting aside the termination order dated 9/6/2016. The petitioner should submit his representation, if any, within a period of 1 week from today, along with a certified copy of this order. In the event the petitioner submits his representation within the specified time period, the respondent number 3 and 4 shall examine the petitioner's representation and take a decision thereon by way of a speaking order within a period of 6 months from the date of receipt of the representation. While passing the speaking order, the respondent number 3 and 4 shall specifically make a finding as to whether any notice was issued to the petitioner or inquiry initiated against the petitioner prior to issuance of the impugned termination order dated 9/6/2016. It is needless to add that in the event the petitioner is aggrieved by the decision made by the respondent number 3 and 4, the petitioner shall have the liberty to approach this court again. So, as per the direction, the petitioner submitted his representation to the respondents. Now, after this, without reinstating the petitioner who was terminated in 2016, they issued this annexure D, page 22. Departmental inquiry was initiated, and this annexure D was the termination order, Lordship. the first termination order. This is the second termination order.
Yes.
Yes. So this was the second termination order. And
The second termination order was also interfered with. When they gave the assurance to the court that we are going to reinstate him, and is it not?
yes,
Then before giving you a reinstatement order, they give you another show cause
notice without
memorandum of charge, and on the same day they also appoint the
the
inquiry
third-
officer and everything. Then you approach this court. When you approach this court, they give you a order of the previous day.
Exactly,
Then you are
Lordship.
reinstated.
I don't have to say much, Lordship. That is very arbitrary, and this is like a witch hunting, reason based known. And if to say so, I honestly even advise the petitioner, and from the first inquiry itself, he has admitted, yes, I slept this one I did not include annexed in my writ petition because it was annexed in the previous two writ petitions.
Okay.
So the last paragraph, Lordship. I have admitted that, yes, I slapped my colleague. That also was already admitted. Now again, they have issued again disciplinary proceeding. This is the third one. And that also without, as my lordship has already conversed with. So this is it. And now what has happened is, lordship, they have placed the order my lord has already seen. The letter that was placed before this honorable court while the case was pending. It is reflected in page 27, lordship. The respondent placed a letter before this honorable court stating that they will reinstate the petitioner without back wages. That was the second writ petition was filed for proportionate punishment. Major punishment was imposed upon the petitioner by terminating his service.
Where is the order of the second writ petition?
Which one, lordship?
No, you said the second was filed. Which second was filed?
Second writ petition. Order 26. Annexure F. Lordship, can kindly peruse paragraph 5.
See. Yes, sir.
Then now my lord has already seen the affidavit in opposition. I filed additional affidavit because after this honorable court stayed the disciplinary proceeding backdated, they reinstated me. So 3 times they did not reinstate me, and they started issuing the disciplinary proceeding. That was also
in Hindi. It is called "Pani mein rehkar magarmachh se takkar." है ना? He is staying in the water and he is fighting with the crocodile. Where is your affidavit in opposition?
It's affidavit in opposition.
Have you sent any hand?
I have filed affidavit in, reply to the affidavit in
Let
opposition.
us see what is their, what is their opposition?
My lord, affidavit in opposition was filed on 11 February 2026.
They have only annexed that I have already admitted to my mistake.
Response number 3.
Hmm?
Affidavit in opposition filed by the response number 3.
Yes, tell us.
Your friends. May I please, Your Lordship, before coming to my submission, kindly allow me to read paragraph 4 of my affidavit in opposition. May I read mine?
Just
That with regard to the statement made in para 5, 6, 7, 8, 9, 10, and 11 of the writ petition, the answering Tribunal humbly beg to submits that in pursuance of the Honorable Court Order dated 8/4/2025, passed in WBC number 235 of 2023, the State Council had conveyed a letter dated 16/4/2025 to the deponent, conveying whether the state respondent authorities are willing to reinstate the petitioner service without back wages, and accordingly the respondent authorities had agreed and conveyed the letter number so and so dated 25/2025 to the State Council, wherein clearly mentioned that the disciplinary authority will reinstate the constable or petitioner without back wages. Thereafter, with the consent of the parties, and basing on the letter dated 25/2025, the Honorable Court by judgment and order dated 5/8/2025 had disposed of the writ petition with the direction to the state respondents to reinstate the petitioner's case within 15 days. Subsequently, in compliance of the Honorable Court Order dated 5/8/2025, the respondent number 4 had reinstated the petitioner case by order dated 26/8/2025, with the condition that the period of dismissal with effect from 09/06/2016 to 25/8/2025, that is 9 years, 2 months, and 15 days, shall be treated as such, and it will be counted as qualifying service, that is, he will not be entitled for salary increment and leave dues incurred during the period of his dismissal. However, it is pertinent to mention herein that it is very
Just
clear.
tell us one thing, we will go into all that later on, whether you have
Yes.
the right to
So, my lord,
affairs disciplinary proceeding or not. We'll go into that after some time.
yes.
What is the procedure of a disciplinary proceeding in law?
My lord, here.
Not here, general.
In this case, my lord.
No, general.
Yes.
There, you want to start a disciplinary proceeding against someone,
Yes.
and how do you do it then? You give him a memorandum of charge.
Yes, ma'am.
Then what do you do? Thereafter, what is to be done? You are giving a man a memorandum of charge.
Yes.
Then, thereafter, what is to be done?
My lord, here that every procedure, whatever procedure.
Let us have your memorandum of charge for a moment.
Yes, already
Where is
furnished to the petitioner, my lord.
Show us.
Page number 37 in the writ petition, my lord.
Page number?
Yes. My lord, see.
37.
Yes, page number.
Please read 37.
Type copy at page 37A.
37.
Yes.
Please read.
In pursuance of
Forget the first paragraph. Read the second paragraph.
Constable is directed to submit 5 days of the receipt of this memorandum, a written statement of his defense, and also to state whether he desired to be heard in prison.
Just a minute. You had given him 5 days time to
Petitioner.
do what?
To submit written statement.
Written statement.
Yes.
And whether he wants to be heard in person or not.
Yes.
Thereafter, what? How many days should he get before you start the proceeding? to file his reply, he must have 5 days.
Yes, 5 days.
Then you will take a decision that whether yes, maybe his reply is satisfactory.
Yes.
You will not go ahead with the inquiry.
Yes, ma'am.
And if the reply is not satisfactory, what will you do?
As per the rules.
You will drop it. If you find the
If
reply,
satisfied.
Ah.
Yes, if satisfied.
So before you get the reply,
Yeah.
whether you want to go ahead with the inquiry or not, you cannot. You are a fair man. The disciplinary authority will act fairly. He will not act with a prejudiced mind, will he?
Yes.
No, he has to act very fairly. So now I tell you in this court, sir, I am giving you 1 week's time to file an affidavit. Okay? If satisfied with the affidavit, I may close the writ petition.
Yes.
I take up the writ petition within 2 days. And I say, no, I will now decide. Forget your affidavit. Can that be done? Should that be done?
So, my lord, here.
If that is done, what happens?
Yes.
Answer us.
Yes,
I will
yes.
come to that. What have I said? Wait for the case will wait. Let us understand that. Now, if I say that I will do it before that 5 days are over, what will be the general presumption? I am biased. I don't want to give you the time. I don't want to see your reply. I just want to proceed. Now, if it is not denied anywhere else, when is the inquiry officer appointed? At page 36.
27 August 2022.
And when was the memorandum of charges given to you?
27.
So you are giving him 5 days time to give a reply, to decide whether you should hold a disciplinary inquiry or not. On the same day, you are appointing an inquiry officer and a presenting officer, saying, no, I will hold it against you. Is it biased?
So, my lord.
Is it or is it not biased? Let us stick to this. Is it or is it not biased?
However, my lord, in this case, if the petitioner is aggrieved by this fresh inquiry, there is a provision that she can go for appeal, my lord.
No.
No, it is.
No. At the stage of charge sheet, what appeal? A man is given a charge sheet.
My lord, in the reinstatement order.
A man is given a charge sheet, and a man is also given an order saying, I have already appointed the inquiry officer and the presenting officer. Now you have not given the time. Is it? Have you given the time in your memorandum of in your charge memorandum and the order appointing the inquiry officer? You have not. There is no time given. It is on the same day.
Yes.
Why should we not presume that first the inquiry officer and the presenting officer is appointed in the morning, and in the afternoon you are issuing a memorandum of charge? See, in administrative law, in service law, you cannot prove bias. Can it be proved? No. What can be best done? A court can be convinced, sir, there is enough scope of bias here. They are not following the law. I may not get justice. Now, issuing the memorandum of charge on the same day, as appointing the inquiry officer and the presenting officer, giving him 5 days time to file a written statement to decide whether the inquiry should proceed or not. And then asking him whether you want to be heard in person. If he is to participate only in the inquiry proceeding, why should he be heard in person? He'll appear before the inquiry officer. You don't have to hear him in person. Is it not?
Yes.
So, issuing the memorandum of charge on 27 and appointing the inquiring officer and the presenting officer on the same day without waiting for his written statement. Can this court take this to be biased? We are not going into the other part of the bias. First, you hold an inquiry. See, first you hold an inquiry. In that inquiry, you don't tell him anything. You tell him, go home, thank you. When was that? Where is that first order?
First order of double petition.
Termination.
Termination is 2nd.
9th of June. Is it?
Yes, Lordship.
9th of June 2016. Is it?
Yes, Lordship.
Page 18.
Page 18. This is the first termination.
Huh?
This is the first termination.
Is it? Page 19? Page 18, I'm sorry.
Page 18 of my petition.
Yes, my lord.
Yes, it says temporary service, we are terminating you.
Yes.
Now, while terminating a temporary service, you cannot use the word disciplinary ground. Am I correct? If you're doing it during the probation, you cannot refer to a disciplinary proceeding, you cannot impute any misconduct on him. But you are saying on disciplinary ground. Yes? Then he comes back to job on 27 to 2019. It is said that he would be given the liberty to go for an appeal, a representation. And what happens on the representation? What happens on the representation? You say that so and so was appointed on Iman, orderly room was conducted on Iman, against so and so, officer submitted orderly room report and said delinquent admitted his guilt. Officer also enclosed the statement of the delinquent admitted his guilt. However, so and so moved the Gauhati High Court to petition. Okay. Then gave liberty to approach. So and so submitted his representation prayer for reinstatement. Accordingly, he was reinstated on 5/4/2019 based on court order and pursuant to so and so in order to have a just and unbiased decision. Passing out a full-fledged department inquiry was constituted and memorandum was served on so and so. Whereas so and so was appointed as inquiry officer, presenting officer, the completed department submitted the report on 12/4/19, where during the course of inquiry, it was found so and so established against him or can proved. Do you have the records of the case?
No, my lord.
The earlier ones. Then what was the first order?
Chief,
Question.
the second affidavit in opposition in the second writ petition is here with me.
How many writ petitions are there?
3. First, second, and this is the third one. The present one is the third one. That is the second writ petition, affidavit in opposition that was filed. In writ petition,
Just a minute.
but that was never served to me. My reinstatement.
Just a minute.
It was just annexed in here, affidavit in opposition.
See, I did not read this. Have you read the order dated 10/4/2025? Yes, sir. What is this 5th of April 2019? 5th of April, you were reinstated. Then what happened? 5th of April itself, you have given another memorandum of charge. Same memorandum.
Same memorandum served to me after expiry of 48 days. And then I was terminated. Only after my termination, I came to know about the issuance of the memorandum. I have annexed all the receipt also when I received. 48 days after expiry of 1 month.
Just a minute. This letter which was given to you. Where is the second page? Where is page 19 to this? Page 19 is not here. Very
Lordship,
important page.
Uh,
At least for me, it is very important.
it was their affidavit in opposition.
Hmm.
And since they annexed it,
No, here there's a page 18, then there's a page 20.
Lordship,
I was trying to find out page 19. 19, yes. Even your earlier letter also goes 15/4/2019. The earlier termination should have. While giving him a show cause notice, you are saying that you are convinced of his guilt. You are giving him the inquiry report and saying, I am convinced of your guilt. What use is that letter? What use is that giving him that inquiry report? You are already biased. See, bias is apparent in this case.
So, my lord, in the first case regarding the inquiry,
first time you do not give him any notice, nothing. You simply say that temporary service on disciplinary ground, I am dismissing you. No inquiry. Court says, okay, file a representation. He files a representation. You reinstate him. Once you reinstate him, on the same day, you give him a memorandum of charge. Same day, 5th of April, you give him a memorandum of charge. Then you show that you have held an inquiry. 12th of April, that is 7 days later, the inquiry officer and the charge employee, they signed this paper saying that, okay, I am pleading guilty. That he admits and pleads guilty to both the article of charge against him. He does not give this paper to the discipline authority. Gives an inquiry report, a full inquiry report. Then the discipline authority gives this man the inquiry report saying, okay, you are very, very guilty man. Take the inquiry report. Tell me what you have to say. Already you have held him guilty when you are giving him the report. You are biased. Then he approaches this court. This court gives a long order, interim order, very long one. You understand that you are wrong. And there one of the grounds taken is, please see. Come to page 30. Yes, where is that? Page 29. Para 3. Additional affidavit was filed by the petitioner. Do you find the
Yes.
paragraph? Okay.
Yes.
Now come to the next paragraph. Sorry, not the next paragraph. We'll make it shorter. Page 30, para 5. What I was asking of you. Ms. So-and-so, behalf of the petitioner, submitted that the instant case, the inquiry officer was appointed on 5/4/19, on the very day that the memorandum of charge is issued. The petitioner was called by the inquiry officer on 12/4/2019. Learned Counsel submits that there could not have been any inquiry before the completion of the 10 days, as has been specifically mentioned in the order dated and the memorandum dated 5/4/2019. All this was recorded in this order.
Yes.
I did not read it, but when I'm going through the file, I'm seeing the same thing. I'm asking you the same thing again. Memorandum of charge, 27th. Enquiry officer appointed, 27th. Giving him 5 days time to file a written statement to find out whether an enquiry should be held or not. So is this enquiry not a mere eyewash? Does it not show the biasness of the disciplinary authority? That I will give you all the documents. I will hold you guilty. My mind is made up. Do what you want.
My lord, so my humble submission is that impugned order which is challenged by the petitioner is that inquiry was issued as a fresh inquiry, my lord.
We will quash this. We will hold this to be an institutional bias against the petitioner. The institution itself is showing a bias against the petitioner, whoever is the commandant. The only intent is to hold him guilty, give him a charge sheet and hold him guilty.
My lord, your lordship, kindly see page number 33. Why the fresh inquiry was conducted, my lord? Your lordship, kindly see in the petition number 33. Read petition number. Not 33. 35A. For the page. May I read, my lord? The paragraph. On the subject cited above, in accordance with the order dated so and so, reinstate Constable so and so without back wages, you are therefore directed to take necessary steps and furnish a copy of the reinstatement order to the undersigned at the earliest. Further, it is also directed that fresh departmental inquiry proceedings be initiated as there were procedural lapses in the previous departmental inquiry. Since in the previous disciplinary proceeding inquiry there was lapses, man. That is why the fresh inquiry was conducted.
That you did not place before this court.
That is the
That you did not place before this court.
that is the when
What was the procedural lapse?
Since that opportunity was given, not given to
Which
the
opportunity?
to her.
The order of the court records. Forget the opportunity part. You could have produced this and said she has admitted everything.
Exactly.
That is done before the court. The court notices that you have started the inquiry on the same day as the memorandum of charge. Memorandum of charge given, inquiry officer appointed, presiding officer appointed. You say, okay, there is a procedural lapse. And what do you do now? Same thing.
And my lord, in the judgment and order that
there is no bar to holding a fresh discipline.
Yes,
right? Because it was not proposed.
No bar.
It was not proposed. It was playing tricks with the court. It was trying to play a trick with the court.
No, my lord.
Yes. You tell the court the repetition is gone, we'll reinstate him. Don't say anything about the disciplinary proceeding. You'll get it. That was the advice. Whosoever had given it. And let us see one more thing. Why is the department after one man for one incident? We'll have it listed in the next week or any day that you want to. Or we can dispose it of today. Your choice.
Lordship, I pray that this may be disposed of today, Lordship.
Short of time. Yes.
And my lord, in regard to that holding of wages, my lord, that increment and all in that reinstatement order. That one, my lord, since the petitioner has also agreed, because in that letter, while disposing the writ petition, the respondent has submitted one letter saying that the petitioner service will be reinstated, but without back wages. So she agreed. So on consensus, that order.
What was the back wages?
My lord.
Back wages.
What was the back wages?
No,
what is back wages? What is the definition of a back wage?
Lord,
does it include seniority?
No, my lord.
Wages cannot include seniority.
My lord, that petitioner was dismissed.
Does the back wage include pension? No.
No.
Does the back wage include continuity in service?
No.
No. So you will not give back wages, why not give the others?
My lord, the dismissal period
Hmm?
during that time, that when the petitioner was dismissed from the service,
Ah,
that is with effect from 09/6/2016 to
on the basis of a
yes, that period.
on the basis of an order which today you have made a submission was not a correct order. Is it? You said today that you withdrew that order because it was not a. Where is that letter you had shown us of the DIG? The DIG says so, na?
Yes, my lord.
The earlier proceeding is wrong.
Yes, my lord.
Is it?
Yes.
So if a man is terminated due to a wrong proceeding, does he lose his back wages and arrears and back wages? Dipali Kundu Suru ase? Entitled? Could you have stopped him? No. So she agrees, okay, no back wages. How can you stop the rest of it?
Is exactly, Lordship.
Continuity in service will come. Seniority will come. Increments will not come because he lost. Increments we are doubtful. But continuity, seniority, pay fixation, he gets everything. And then the mistake that you committed in the earlier occasion, you have committed now again. We don't find it.
In fact,
We will say that we have caught a whiff of institutional bias in this case. Therefore, we are quashing this memorandum of charge and we are quashing and we are restraining the respondents. Yes. What was the case?
Lordship, I have some citations.
Give it.
Citation
Yeah, Eugene.
2022 8 SCC.
There's one case of the Gauhati principal seat itself where
There is
the court has held.
GLT.
A lot of time has now gone, sir. Forget it. Forget the issue. Find a new one. Finish it.
This is our own.
Lot of
Gauhati
time
High
has
Court.
now gone. One drink and one slap. Over.
Just on
Has
that
he not-
aspect.
Has he not suffered enough?
Exactly, Lordship.
Huh? Has he not suffered enough?
9,
What is
paragraph 9, GLT.
Para 9.
Para 9, 2015 GLT. This is from Nagaland also, exact. And here, the petitioner committed heinous crime, not like me, just a slap. Para 9, Lordship.
And what was done?
This now leads to us to question as to whether the petitioner will be entitled to back wages upon his reinstatement in service. Before passing the impugn order of removal from service, the petitioner was serving as a driver under the respondents. Nothing has been stated that after such removal from service, the petitioner has not engaged himself in any other assigned jobs. Even otherwise, also, in the given facts and
No,
circumstances,
this inquiry did not proceed against you. When they appointed the new inquiry, what is the stage of that inquiry now?
now, it has already been stayed by this honorable court in
At
an
what stage? It was given to you on 27/8. Where is the order?
Right after the issuance, I approached this court and it has been stayed, Lordship.
Where?
27th.
Where is that order? Kindly show us.
Oh. The first-
29/8 it has been stayed, huh?
Yes, Lordship. 29th. After this is stayed, they issued my reinstatement order, backdated. And I had to file in additional affidavit because
My lord, I leave it to your lordship and my submission will be
Your submissions that the earlier order did not debar a memorandum, debar a first disciplinary
I have
proceeding
and already stated in my affidavit in the bara form.
what it was, tell us, we'll to record.
Lordship here also, with my humble Lordship permission. However, his service continuation shall be maintained, providing all other benefits, including increment.
Oh, madam, you did not get that order in the earlier occasion. Why did you not place all this in the earlier occasion? Para 4.
Yes, my lord.
Para 4, which part should we record? We can't say that the council has been asking them and they have agreed to it. Shall we say that in the order?
No, my lord.
I cannot say that. So what
Because
should I
my
say?
lord, from
However,
Accordingly, the respondent authority has agreed and conveyed that para
now
4,
come to the next page.
line 1 to
Please come to the next page. Is it okay if we record from however?
Lordship, may kindly note from the para 4, line 1, 2, 3, 4, and accordingly, the respondent authority has that one from.
This was
Yes.
heard, Mr. So-and-so. Heard Ms. So-and-so on a
So
consent.
I have other authorities also. That is,
Don't make it too
this is
long.
also exactly, no, I'll just give the paragraph. This is 2022 8 SCC 378. 370. Twenty 8 SCC.
Okay, we are not keeping this CAP because we have to go for a visit to some. We have some
Okay.
assignment again at 3 o'clock. So I will not be able to defer the judgment.
I was just humbly praying before the Honorable Court for consequential benefits. If
Now,
Lordship,
consequential benefits, up to your illegal termination, you had already given up everything.
now I have been reinstated and there is at least more than 10,000 differences from my batchmates.
No, those consequential benefits you will get, but no back wages.
No back wages.
No
back
back
wages I have already given. That's why back wages is enough for, at least I have lost back wages 40 to 50 lakhs, Lordship, from 2016 to 2025 when I was reinstated.
9 years, 60 lakhs.
Oh, no, not 60, 40. I'm saying 40.
1/4.
Yes, in my writ petition, I have also included it is they who provided me along with my wages. There is a differences more than 10,000 now. So those are my grievances also in my affidavit in opposition, Lordship. It was first time I got my salary just last month. And right after the differences, the pending, after I was reinstated, my first back wages, I have shown in my affidavit, additional affidavit and affidavit in my opposition, Lordship. These are very relevant.
Okay, we are keeping a copy of this affidavit in opposition of WPC 235 of 23
Lordship.
and the daily order sheet of preliminary hearing. Please, sisters,
Lordship.
you'll get it back once we release the file.
Lordship. Also,
So just
1997,
Take the attendance, keep as disposed of.
1997,
See if we can find it.
para 2, 1997, 11 SCC.
Do me one more favor, madam.
Lordship.
Kindly give me the printouts of this.
Lordship can take mine.
I'm giving you back this one also.
Humbly, Lordship.
You give me the printouts of all the judgments you want to be referred along with para numbers written on the top. If you have any judgments to rely upon, but otherwise, you see, the question remains. Memorandum of charge on the same day, asking him to file a written statement and saying that inquiry will be held only if you don't admit anything. If I'm convinced, I may drop the inquiry is the rule. Without waiting for that, on the same day, you are appointing an inquiry officer and a presenting officer. Likelihood of bias. And therefore, that this memorandum of charge has to go. This court has tried on each of the earlier occasions not to bring on record the bias of the disciplining authority. By this last memorandum of charge, you are forcing us to put on record the bias of the disciplining authority. What to do? Yes. Disposed of. We'll give this in my chamber and dictate it after I come. Disposed. Okay, thank you.
Humbly obliged.